we move an application seeking for the discharge of the defendant on all the counts, the 15 counts filed against the defendants. And the court, in its wisdom, now reviewed all the charges and discovered that with the exception of 7 counts, about 8 counts appear to be similar, and those charges were struck out. Now, it would be also understood that in the argument of the defendant, the accounts that is reflected in the charges, when you go to the charge, you get to know all the counts. But all the counts relating to terrorism are really sustained by the court. And make heavy weather on the issue of rendition, and the court bluntly said that rendition in this situation is allowed, because rendition in criminal law, in criminal case, is allowed. After all, the defendant is under a bench warrant, and anywhere he is seen, the law allows him to be taken and be forcefully brought to court, and that was what exactly happened. And again, with respect to membership of IPOB, which he denied, it was the argument of the defendant that the matter is on appeal on whether IPOB is a proscribed organization under the Nigerian law or not. The court also emphatically said even though the issue is on appeal, but what is in place is that IPOB still remain a terrorist organization within the confine of Nigerian law. And immediately thereafter, they moved another application for bail again, which the court ordered that such application be taken, and arguments were proffered. And it was also in their argument that Nnamdi Kanu had never flouted any of the conditions of the bail. And we have argued vehemently, showing to the world, showing to the court that he has actually flouted all the bail conditions. And that was the reason why the court has ordered for his, revoked his bail and ordered for his arrest. And it was also our argument that what we should be talking about is contempt of court, not even issue of bail anymore. And we are awaiting the response of the court on the next adjourned date, which the case is now adjourned till the 17th, 18th, and 26th of May 2022 for ruling and continuation of hearing. But one thing that is very significant that I thought I should mention here is that the court has already hinted us that arising from the new practice direction, considering the inconvenience this case has always caused other courts within the premises and other offices within the premises, moving forward, this case will be heard in other places that will be communicated to parties before the next adjourned date. This, I thought, is very important, and I thought I should let you know.
Sir, journalists were today, accredited journalists were barred from gaining access into the courtroom. What's the position of the prosecutor?
Well,
we just afforded you the platform to tell Nigerians what transpired in the courtroom, and we were not allowed to go into the courtroom to report the proceedings.
Well, I think with respect to that, that will be the business of the information unit of the Federal High Court. I am to give you what actually transpired in the court. So I'm afraid I'm not able to. I will not be able to respond to that.
What about the jurisdiction that are also being challenged?
Well, the issue of jurisdiction, already the court has already sustained that. I mean, refused that issue of jurisdiction. This court has the jurisdiction to entertain this matter, and that is the more reason why this matter will continue with the remaining 7 counts against the defendants.
Today, after the counts were quashed, particularly counts 1, 2, 3, 4, 5, 8, and 15, they were quashed. Those are the ones that are remaining. The other ones were quashed.
6, 7, 8, 9.
So we then proceeded to move our bail application that the defendant, Mazi, Nnamdi Kanu, deserves to be granted bail. The case of the prosecution has always been, and this is sheer falsehood, that Nnamdi Kanu jumped bail, and that was why he was forcibly renditioned back to Nigeria. A rendition which the court did not agree with us today, which we shall test, that is contrary to provisions of the African Charter on Human and People's Rights, contrary to the Universal Declaration of Human Rights of 1948, contrary to the International Covenant on Social and Political Rights, contrary to the instrument dealing with indigenous people's rights. When you have a treaty with a country such as Nigeria with Kenya, and a person voluntarily entered Kenya, and you renditioned him forcefully through torture, inhuman and degrading treatment back to Nigeria on the 27th of June, 2021. All the cases based on my research across the world show that such a person cannot be tried. Cannot be tried at all. Based on that first original sin, the type of original sin committed by Adam and Eve in the Garden of Eden when they ate of the forbidden fruit. You cannot try such a person. We will try this one. That he jumped bail? The answer is no. Nnamdi Kanu was enjoying his bail. He was within Nigeria. He never left for abroad. Then on the 14th of September 2017, the military went in armored trucks as if they were going to war in Sambisa forest and invaded the home of Nnamdi Kanu and his father, His Royal Majesty Kanu, who is now late. Invaded it brutally, savagely, and mowed down 28 innocent Nigerians that were there without cause. They called it Operation Python Dance and other operations. We've not seen Operation Python Dance in Sambisa Forest and Chibok and Dapchi. They murdered 28 innocent Nigerians in cold blood. Somehow, Nnamdi Kanu, like the cat with proverbial 9 lives, was able to escape. Are you saying that a person who was to be killed and ran away from certain death jumped bail? The answer is no. So you are saying Nnamdi Kanu, after escaping barely with his life, should wait in Nigeria. If he had been killed, he wouldn't be standing trial here. So he did not jump bail. Rather, they forced him into exile. And he went as a citizen of Britain to Kenya, where he was forcibly and forcibly under torture, inhuman and degrading treatment, renditioned back to Nigeria. So this is a case deserving of bail. And we implored my Lord to grant him bail, even if she wants to subject it to certain conditions. Let me tell you, even under the Administration of Criminal Justice Act, bail is allowed. I do not believe in secret trials, because Section 36 of the Constitution talks about open trial. But the point is appreciated that each day this matter comes up, other courts are closed down, and that other litigants are not allowed to have their day in the market. I'm fair-minded enough to know that a system that does not allow other litigants to have their day in the court just because of one litigant cannot be said to be fair. I'm a human rights activist and constitutional lawyer. I know that my conscience, also as a Christian, does not agree with that. But there are areas in the new practice directions that I correct with. In other words, I do not mind if they move the venue to another place that does not disturb other litigants and clients and witnesses and other. But I'm worried about one provision. that screens off journalists, the media, the fourth estate of the realm under Section 22 of the Constitution. Because if you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. The Supreme Court says so, and I think that was in the case of Adesanya versus President of the Senate. If you stifle information, then the rumor mill will become very active, and things will begin to germinate. We have a proverb in my home, in my language. I'm from Iyukwe, near Agenebode, Isako, East Local Government Area of Edo State. The proverb is, Ono ayoelaza vuyuko, lo hazo moagule. What does it mean? He who was not present when a fat he-goat was butchered, we argue later that a fetus must have been removed from his tummy after it had a big tummy. In other words, seeing is believing. You don't hide information. So when you prevent the media from covering a trial, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary itself. In terms of witnesses attending, I have no problem with witnesses being screened off. That is good to safeguard the interests of the witnesses and the fact that you refer to them as A or B instead of by their names. That safeguards them. That is a very wise decision. Safeguard witnesses, screen them off. Or if you want to use Zoom, fine. Although that is subject to whether, when you use Zoom, whether cross-examination can also be allowed in that method, or whether the court can be said to watch the demeanor of the witness. But I am particularly, and not therefore much against the issue of shifting the venue to a more convenient place. That is fair enough. I'm not against the issue of screening of witnesses. That is fair enough. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend, the same way it has been, we have been doing it. I believe that because of that, by the grace of God, I'm going to challenge some portions of the new practice directions as being unconstitutional and against so many sections of the Constitution of Nigeria.